Good morning, everyone. Let me just wait a few seconds so the Zoom room can be populated, and then we'll get started. All right. Good morning, and welcome to this meeting of the Committee of the Revision of the Penal Code, which is now in session. I am Mike Romano, Committee Chair, and I'll be your host for this morning. Let's begin with a roll call of committee members in alphabetical order. Assemblymember Bryan is not with us quite yet. Judge Espinoza,
I'm here.
Mary Kennedy,
Here.
Professor Ochin is on her way, but will join us later. Professor Rummel, I see you.
Muted, but here.
And Senator Wiener will also join us later, hopefully. Okay, our main topic for today, as many of you know, is the implementation of California's Racial Justice Act, which was passed in 2020 and expanded by the Racial Justice for All Act in 2021. We're going to begin with a presentation on research by our friend, Professor Steve Raphael, and work that he's done on racial disparities in California's criminal justice system, and particularly the prison population. We'll then have a staff presentation about the RJA and panel discussion. After lunch, we'll hear from staff about research on other topics, including recent 2024 crime data, and then we'll conclude, as always, with public comment. Before we get started, as always, we are governed by the Bagley-Keene Open Meeting Act. The law requires that members of the public can watch and participate for this meeting in person at the first floor of the conference room at 925 L Street in Sacramento. And thanks yet again to Megan for being present there in that location. As a reminder to the rest of us and committee members, the law requires that committee members must, quote, visibly appear on camera during the meeting unless there are technical difficulties or a screen is being shared. If you do have technical difficulties, please let us know and we'll handle it from there. Okay, with that said, I want to turn to the main topic and say a few words about the Racial Justice Act. Okay, I think everyone truly agrees with the goal of the RJA, which is eliminating racial bias from California's criminal justice system. But almost everything else about the law has been heavily contested by public defenders, prosecutors, courts, and lawmakers. The RJA has been law for more than 4 years, and this is not the first time that the committee has studied it. No one thought that the RJA would work vast changes on our criminal system overnight, but I am still surprised, and I think many others are surprised by how little progress has been made on key points of the law. And I'm particularly concerned about claims involving systemic bias and statistics. As we'll hear today, it appears that only one case has prevailed under the RJA since its inception. One of the, bias-based case has prevailed under the RJA since its inception. 2 others have reached merits, only 2 others, and both of those failed. Other claims have been mired in disputes about whether initial allegations are sufficient or whether and how much information and data prosecutors must disclose as litigation proceeds. I have seen some of these problems firsthand in working on my own cases at Stanford. We see case after case of people after color receiving what appears to be blatant disproportionate punishment, particularly under the 3 strikes law and gang enhancements, but in other areas as well. This suggests to me a real and significant need for further improvements to the law. I believe that our committee has a special role to play here. Prior work and prior of our reports have been relied on by defendants and the courts as cited as relevant authority in guiding litigation. In the end, I hope that we arrive at significant and realistic recommendations to allow the RJA to have the impact we all hoped and intended it to have. So with that said, let's get to it. As I mentioned, we're going to start with a presentation from Professor Steve Raphael from UC Berkeley, the California Policy Lab. He is our good friend and research partner based out of UCLA and UC Berkeley. His presentation is about racial disparities in California's criminal system, and particularly our prison population. He's going to present for about 5 or 10 minutes, and then we will do Q&A. So Steve, please take it away.
You're muted still, Steve, I think.
All right, can you hear me now?
Yes.
And can you see my screen?
Yes.
Okay, well, good morning, everybody, and thank you for inviting me to present today. Today, I'm going to present some just descriptive work that is intended to provide some context with regards to what's happened to race disparities in prison incarceration in California, especially in the recent past, over the past 15 years. But as we know, during the expansionary period of incarceration in the United States, things like three strikes, the nickel prior, 1 year prior prison enhancements, and other such sentencing policies across the country had a disparate impact on the incarceration rates of African Americans and other minority populations. And in recent times, where we've sort of had policy reforms going in the other direction, whether it be realignment, Prop 36, the 2012 version anyway, and the various sentencing reforms that have happened in the past decade or so, one might expect that that had disparate impacts in the other direction. And that's essentially what we're going to try to study today, is essentially what's happened to incarceration rates, and in particular, race disparities in incarceration rates through these various reform periods. So the current graph is basically showing the number of prison inmates per 100,000 from 1980 through the end of the year 2024. And what we can see is that indeed, during our period of expansion from 80 to about 2007, incarceration rates grew the fastest for non-Hispanic Black people, for Hispanic people relative to white people, and for Native American, American Indians. And then starting at about 2010, we see very large declines that I break into three periods. So in this figure, we have drawn vertical lines at 2010, 2014, and 2019, where 2010 is kind of the last pre-realignment year. 2014 is on the eve of Prop 47, and then a series of other reforms that happen in the interim, the passage of Prop 57 and some changes to enhancement policy as well. And then 2019, post-2019, obviously we have the pandemic, and then other policies impacting things like the 1 year prior prison enhancement, and also reforms to parole for people on indeterminate sentences that made more people eligible for parole due to elderly parole and juvenile parole reform. And what we can see is quite a narrowing right in the gap. So at its peak, there was almost a difference in incarceration rates between Black, non-Hispanic Black and non-Hispanic whites of over 2,000 per 100,000. And in the most recent year, that's narrowed to under 1,000 per 100,000. So there's still a large gap, but it's much smaller now after the wave of reforms than it was in the past. So, and just to, while we don't have similar information on the race composition of jail populations, we can at least look at the overall jail population and just note that the large declines in incarceration have not corresponded with a ballooning of the average daily population of our county jails. That there was a partial offset after realignment happening around 2011, but in recent years, our jail population is approaching historically low periods. Okay, so, well, just one more picture, just kind of laying out the graphs, and then I'm going to sort of talk about causes. So this is just showing the change for each group in their incarceration rate from 2009, 2014, 14 to 19, and then 19 to 24, these three periods. And we can kind of see that the realignment period and the period since the pandemic have been periods of particularly large declines for incarceration, and the largest declines have been observed among the Black population and the Native American population relative to other groups. So what are explaining these declines, or what do we see in the data? So from 2009 to 14, most of the declines that we see are being driven by reductions in the proportion of the population that's incarcerated for parole violations. And there are the largest absolute impacts on the incarceration rates for Black people. From 2014 to 2019, most of the reductions are being driven by reductions in incarceration due to drug and property offenses. Again, the greatest impacts are observed for African American incarceration rates. And then in 2019 to 24, we see the largest declines being driven by declines in incarceration for violent offenses, for murder, robbery, other assault, and then also for burglary. And again, we're seeing the largest impacts for Black, and then in this instance, also Native American incarceration rates. And just to give a sense of what this means, so this table is just taking the change for each group over these three periods and kind of saying what proportion of the decline is due to decline in violent, property, drug. If it's negative, it means that incarceration rate actually increased. And we can see for all groups, parole is important during the first period, property and drug declines are important during the second period, and declines in violent and property incarceration rates are driving the third period. Okay. So just a few more slides to focus on the most recent declines. I guess I hadn't really taken a hard look at the most recent years until about a month ago, and I was kind of surprised at how large the decreases were. So we tried to get to the bottom of what was going on there. So one possibility was that there were, COVID-related population reduction measures taken by CDCR to try to relieve the amount of population overcrowding to control the transmission of disease. One was there was a temporary reduction in admissions, although those resumed after a short time period. There was a speed up in releases, occurring over about a 7-month period with the onset of the pandemic. And basically all those with 6 months or more remaining on their sentence were released a little early to try to relieve overcrowding. And then there were also credits, additional credits of about 3 months given to everyone who was incarcerated from about March to July who didn't have any serious RVRs. We don't think that this really had any permanent impact on the population because once we sort of get through the period where you've sort of borrowed the future releases, this should not permanently impact the prison population. However, we also, when we just compare, say, 2024 to 2019, we see sharp reductions in some key admission rates, not all admission rates, but for some offenses. And we also see permanent increase in release rates. And the latter is particularly important because release rates and sentence length are inversely related to one another. So the higher the release rate, the shorter the amount of time people are serving. So it suggests that either the changes in enhancements or the change in parole policy are shortening time served and then having a consequent impact on the prison population, and then a differential impact on the race, on different groups by race, ethnicity. So in terms of the release and admission rates, we see sort of what appear to be permanent declines in admission rates for robbery, for other assault, battery, not assault with a deadly weapon, and then for burglary, and then notable increases in release rates for these offenses, but for many other offenses. And just to give a sense, just at least for these four, over the 19 to 24 time period, we can see declines in overall incarceration of 8% for murder, 41% for robbery, 25% for assault, 50% for burglary. The changes in admission rates, you can see nothing for murder, right? In fact, it goes up a little bit because there was a spike in murder during the pandemic. But for robbery, assault, and burglary, there are large declines. The release rates for all these offenses go up, 14% for murder, 36% for robbery, and so on and so forth. And then when we look at crime, there are declines in crime rates for some of these, in particular robbery and burglary, but the declines are not large enough to sort of explain these declines in admissions. And so it does suggest that policy is having a bite and reducing the population and having a disparate impact on Black and Native American incarceration rates in the last 5 years. Just one more quick slide, and I promise I'm done. We also went through we've built a little simulation model that allows us to kind of sort of alter counterfactually the admissions rates and then also the release rates or alternatively the time served to kind of simulate what would happen if we returned to 2019 values, if we changed an admission rate or release rate for one particular crime. And what basically, and we have a whole series of simulations we did for all groups, but just to illustrate the importance of particular offenses, we applied our model to Black incarceration rates, and we're basically finding that the changes in release admissions for aggravated assault, burglary, murder, and manslaughter are accounting for most of the decline that we observed from 2019 to 2024. Finally, just a quick note on crime trends. So violent crime is still, roughly at a historic low. There have been some recent increases in aggravated assault rates, though for robbery, homicide, and rape, the rates are low and they have not increased appreciably with declines in incarceration. There's a big increase in reported rapes having to do with a change in the way the offense was defined in 2014. And then finally, for property crimes, they appear to be declining, or at least sort of at historically relatively low levels in recent years. And that's it. So thanks.
Wow, this is super helpful, Steve. I have a couple of questions, but I was wondering if any committee other members have before I jump in. Or staff. Okay, seeing none. Steve, among you, at the beginning, you showed a number of the reforms that have been enacted in California. It seems like, depending on how you count, at least a half dozen. And of course, I know that you are working with us on a big report on the outcomes of, I think we're doing six, is that right, Tom? Six of the reforms? Five, and then we're reserving Prop 57 separately, correct? Am I correct in that? For a separate report. Among these reforms, and I'm going to include Prop 57 for immediate conversation, are there any of the reforms that stand out to you as having a particularly strong impact on reducing racial disparities?
Well, yes, certainly. I mean, you can in some ways see it in the data. So realignment was particularly impactful. We can kind of see over this time period where there's an enormous decline in the population that is basically just serving time on a parole violation. And there's prior work on that in the sense that we have seen just given by virtue of the fact that there are disparities involved in the criminal justice system, that a reform such as changing the nature of a technical parole violation is just going to have a disparate impact on the population that's the largest. That was a pretty impactful. Prop 47 was impactful as well, although it didn't have as big an effect on the incarceration rate as some of the other reforms. There are other dimensions where you actually saw very large impacts. So, for example, if you compare felony arrests on either side of 2014 for drug offenses, you actually see a reduction in the felony drug arrest rate for African Americans in the post 47 period. That's below what it was for white non-Hispanic white people in California in the pre-period. That you see this great kind of contraction in the disparities in arrest rates, and many of those offenses wouldn't result in a prison sentence, but you do see a big shift you do see a big shift in just the felony arrests, a shift towards misdemeanors. And then in other work we've done, we've actually seen that in court cases that turns out to sort of, narrow a whole bunch of disparities when it comes to pretrial detention and the outcomes of cases and so on and so forth. And then in the most recent period, um, you know, despite the fact, I mean, this does occur during the pandemic, whatever it is that's driving this large decline that we're seeing in the most recent years, and the one thing that we're struggling a little bit to understand is why admissions conditional on arrest seems to have declined over this time period, and we're trying to get to the bottom of that. But it does appear that many of the reforms target towards more judicious use of enhancements have really greatly narrowed the disparities. And in fact, the effects appear to be larger than what we observe for realignment. And I mean, in general, it's kind of a fascinating thing to just consider, what happened over this time period where you can kind of see that, like, here's the offense distribution of people that are incarcerated, and you can kind of see the differential effects across these three reform periods where, generally speaking, what contributes the most to a state's incarceration rate are going to be the longest sentences, right? Because it's the incarceration rate is kind of a combination of what's the rate at which you're admitting people and then how long are they there. So to the extent that reform attacks extremely long sentences or modifies an extremely long sentence, even though those folks are a small number of the people admitted at any given year, they turn out to be a large number of the people incarcerated in any given year because they collect, right? If they're there for many, many, many years.
Professor Rummel.
Thank you. Given what you just said, Professor Raphael, I'm curious if you have specific data on how parole reforms, which is almost always long-term offenders, the discretionary parole process in California, where we've released, 11 or 12,000 people in the last decade, and BPH reports indicate that there is very little or very racial disparity among people who they are deciding to release. That doesn't obviously address who's being admitted for those crimes in the first instance. But I wonder if you have any data on the effects of the parole reforms, more people having a more reasonable opportunity for parole after 25 years and the release rates under that system, which purports to have very little racial bias.
Yeah. So we haven't dug into that yet. That's part of our ongoing work on this latter time period. But it is the case, for example, when, one of the things that we're seeing in the data, right, is that, and I'll fast forward to one slide, is that there's a sizable decline in the incarceration rate for murder one, murder two, and manslaughter, right? So if we combine those three groups, the admissions rates for those groups have not changed, right? So in fact, they went up, but the release rates increased. And we think, and and it's not explaining the lion's share of the decline, but a sizable portion for African Americans, Native Americans. And the fact that the release rate increase kind of hints at the effect that perhaps people who otherwise, say, prior to moving the elderly parole age from 60 to 50, or being able to consider juvenile LWOP cases, are now granted a shot at actually being paroled. We suspect that might be what's driving this decline, and that's something that we're kind of digging into a little bit in the analysis that we're gonna ultimately produce for this report. But that's what we suspect is happening.
On that point in particular, I'm curious to know how big a role manslaughter plays in that calculus, because of course that's a determinate sentence and doesn't touch the parole process that Heidi was referring to.
Yeah. That's a good question, and I'm not sure, but I'll note it and we'll make sure to include that in the report.
Other questions?
I had a one or two questions, if that's okay.
Mhm.
Steve, I think also what happened in the later period is there was increased eligibility for higher credit earning too, and since that applied to so many people who are in prison, even if the extra time they got off maybe wasn't that high per person, if you sort of add that up over, the huge number of people we have in prison, that might be playing a role here at all. What do you think of that?
Yeah, that's certain. Well, this is in addition to the credits for good behavior during the on.
Yeah, sort of just the base, the
Yeah,
normal time
yeah,
credit
yeah.
earning stuff.
I mean, yeah, that certainly could be a factor. I'm not sure numerically, like how, of course, if you increase credits, that's going to increase release rates and shorten time served. But I'm not sure numerically how important it is relative to, sort of a reduction in the age for elderly parole or eliminating a year sentence. I mean, it's interesting because we have a PhD student who's working on some of the resentencing, and you do see discrete declines associated with the retroactive applicability of the 1 year, 1 year prior prison term and things like that. So there are some notable changes in
Mm.
sentencing over this time period. And, credit earned is one, and then the sentences and the retroactive resentencing, that all of these are definitely contributing to kind of shorter time served.
And you had also mentioned the admission rate sort of in relationship to the arrest rate, because I'm also struck by that the arrest rate has gone down so much since COVID and sort of stayed that way. And I wonder if it really doesn't seem like a big question mark, like why? Because that to me sort of would eventually drive the prison admission rate. Of there's less people being arrested, there's going to be less people charged, convicted, and admitted. So it seems like that is playing a big role in why the arrest rate has gone down so far. Even if it can't just be we've seen sort of crime decline in so many categories. It seems like it's outpacing that too. I don't know if you've thought about that at all.
Yeah, well, it's certainly, for example, like robbery and burglary have declines in admissions of nearly 40% and declines in the crime rates of 10 to 19%. I mean, that gives me a chance to show the bonus slide. Um, we did kind of an analysis of admissions rates for specific broad offense categories. And the red lines are basically the admission rates from 2014, 2019, and you can see a dip in 2020. And these are all offenses where admission rates either sort of returned to previous levels or exceeded them in the post-pandemic period. And these are offenses, where you wouldn't expect reforms to impact the extensive margin. Like if you're arrested and you're convicted, you're probably going to prison for these things. When we look, and then these are the offenses where we saw, admission rates not recovering, right? So it's like robbery, you see a discrete decline, other assault. So for assault with a deadly weapon, you don't see this. Burglary first. Burglary second drops a lot during 2014, but for most of these, you can kind of see what are the offenses that are not recovering. And I'm not quite sure whether this reflects a decline in arrest or a decline in admissions conditional on arrest, but I suspect it's the latter.
Mm.
And that's, so we're going to try to dig into that and have a definitive answer. Professor Rummel?
Thanks again. Sorry. Do you have similar data, the way you've broken down the different crimes for enhancements, gang enhancements, gun enhancements, and the use of those sorts of things?
Yeah, indeed we do. That was one of the things we wanted to see, was whether or not the declines in admissions were being driven by declines in admissions for where somebody has, say, a burglary case plus a prior prison, or a burglary case plus a nickel prior or something of that sort, to try to get some sense of perhaps maybe the alleviation of some of the enhancements is leading to a change in admissions trends. And so we are working, we can, with the administrative data we have from CDCR, attach the enhancements associated with every case to each admission, and that's one of the sets of tabs that we're working on.
Mary?
I was thinking about the enhancements too, kind of the same question, but also because there was a number of enhancements passed right immediately following the 3 strikes. And some of them were passed in lieu of increasing direct sentencing with the thought that they would be used judiciously. So that I wonder, I mean, I think that it's interesting that the trend that we've changed them now has lowered, because I do think some of that bump in prison population was related to enhancements, right after, like kind of in that 10-year period after 3 strikes. So it's interesting that that's also now returning.
Yeah. Yeah, certainly. I mean, that's certainly the case, right? So we did do a previous report at CPL on enhancements, and we did some tabulations of the additional years added by specific, and not in addition to 3 strikes and a second strike doubling. Prior prison is perhaps the most frequently observed enhancement during that time period, which 1 year each, and then the nickel prior, while less frequently observed, adds 5 times as many years. And so they were adding a lot to the kind of bank of years to be served among the inmate population. And then when they're removing them, quite naturally, they're sort of relieved. Yeah.
I had a couple of questions. I know that we can break this down by geography. Given the large drop, especially in 2020, and that your observation that it wasn't just the reforms, but it was actually seemed to be more judicious use of enhancements. I was wondering if you had a thought of, given that Gascon, Price, and Boudin were DAs in large counties, especially Los Angeles, might that have, how big of an effect do we give or credit to them? Can we watch after their removal from office? You expect a change? Have you? And I guess basically, have you done this geographic look and tried to think along these lines?
That is also on our list of things to do. The one thing I would say, however, is that the changes in release rates for a lot of these offenses are not under, I mean, to some degree they're under control, but especially for the very long sentences, these are sentences that, happened decades ago for people that are on indeterminate sentences. So we will do that. And the one thing to note is there are projections. So CDCR has a nice by population projection report that they put out twice a year, and they have projected that the inmate population will be 5,000 to 6,000 people more than it otherwise would be because of Prop 36. They're still predicting declines, but declines that are smaller than they otherwise would be. So there is a reason to think that there's movement in the other direction, right? Clearly with the passage of that ballot proposition. But we can definitely look into whether or not LA is the tail wagging the dog here.
And before we get to you, Judge, in 1 second, your data does not go through this year. Tom, do you know if anybody has the data for the new Prop 36? I guess we've been in it 6 months or so. Can we make any guesses on that?
There is a lot of information about cases that are charged, but I think one of the concerns expressed, especially by public defenders in courts, is because a lot more things are going to be felony charges. They're going to take longer to go through the system. And especially if there's, treatment options available, we won't really know what's happening for a little while longer. But that's something we're also working on with our partners at the California Policy Lab.
But how up to date is the data that we have? So I appreciate that it might not have gotten through this.
We get prison data every month, but there probably aren't that many people who would have hit prison yet from Prop 36.
Right. Okay, got it. Judge Espinoza. You're on mute.
I just wanted to alert Professor Rafael, Raphael, to a couple of things that have happened in Los Angeles County, which I think could be driving some of these reductions, given that anecdotally 30% of the prison population comes from our county. When COVID hit, the daily census in the LA County Jail was over 17,000. And through a series of initiatives that were really collaboratively approached, the population, the daily census went down to 11,000 and stayed that low for quite some time. It's now creeping back up. But one of the things that I think, I don't know how to address this issue, but in Los Angeles County, criminal justice reform has been driven largely by an attempt to close Men's Central Jail. There was a report that was authored by the Office of Diversion and Reentry that created a plan to close Men's Central Jail that involved removing large swaths of mentally ill and other people with unmet behavioral health needs from the jail into community-based treatment. From the period of 2016 to today, roughly 13,000 folks have been pulled out of the jail, placed in community-based care, and a large percentage of that population were charged with felonies. So somehow, when you get around to geographic analysis, if you could sort of take a look at that, and I'm happy be a resource for you as the former director of the Office of Diversion and Reentry. I can put you in touch with people that help explain these reductions.
Sure. No, that would be fantastic. But do you think the folks being diverted is leading to fewer prison admissions because of the diversion?
I
Yeah.
do.
Okay.
And I'll just say, here's the reason. The reason the office was created was to reduce the population of people in the jail with serious mental illness and substance use disorder. That population has become a group that is charged almost, not exclusively, but mostly with serious and violent crimes that are a consequence of their mental illness. And so we're not pulling the low-hanging fruit out, as people used to say about us. We're dealing with some folks charged with serious crimes. So I'm not saying it's the explanation, but I think it's a factor. And I'd love for you to look at that.
Okay. We will.
Thank you.
Yeah, along those lines, and I'm going to ask a couple questions, and then unless anybody has anything pressing, I want to move on. I have received data from other sources that we haven't seen the same um, um, improvements, let's say, the mental health population. And in fact, I've seen data, and I know that there's recent federal court rulings that suggest that the mental health population is actually going up over this period. So I hope that we can sort of also include some of that data and information in our study along the lines that Peter suggested.
Yes, so we can see in our administrative data, we can see people's level of service care or their care service level within CDC,
Right.
which is kind of the flag for whether.
Right. No, I know that that's a proxy, but my understanding is that there are more people in triple CMS and even more people in EOP. So it's not only more population total, but also the acuity seems to be going up. There might be many explanations for it, but it's something that I'd like to keep our eye on. Peter?
I didn't mean to create the impression we solved the problem. In fact, in Los Angeles County, the percentage of the county jail population that has a serious mental illness has gone from 30% to over 40%. So it is an ongoing crisis in the carceral setting, both locally and statewide.
Hardly took yours. Steve, this is the last question. It's a bit off topic, but hopefully it will serve as a transition to the conversation about RJA. One of the things that I think that you'll see that we'll all experience frustration in applying the RJA is that we are a bunch of lawyers trying to do math. And I was wondering, and the answer might be this is too complicated to answer in this setting. Is there a simple or acknowledged formula that says something to the effect of, when you see a racial disparity of X%, that we can say that this is that race is responsible for that effect with some level of confidence if the population size is Y is big enough. Do you understand my question? Is there
Yes,
some,
I do understand. But I mean, so let me see if I can. I mean, when I think about race disparities in the system, my mind immediately goes to disparate impact or differential treatment. And so disparate impact applied neutrally to everybody, but if one group is more involved than the other, it could have a disparate impact. And then that raises questions about whether the neutrally applied law can be justified according to some other social objective, whether it's public safety or what have you, right? So I think, for example, in DUI laws, there are differential rates at which people are convicted by race ethnicity, but you also see differential rates at which people die in drunk driving crashes that perhaps explain those disparities you see. I think when it comes to differential treatment, you know, most statisticians would say that, you know, an observed race disparity might be evidence, but might not be evidence of differential treatment, because it could be that there are differences in case factors that explain those disparities you see. And I think that that's where a lot of times when there's statistical debate, that you know, where a lot of the scrutiny will focus, that there will be the folks who say, well, that we can explain that disparity by differences in this aggravating or mitigating factor, or differences in the offense distribution or what have you. And then people might try to statistically control for them. And if it's still there, they'll say, but you haven't controlled for this and you can't observe that. And so there's a, you know, I don't know if there's a hard and fast way to kind of, you know, or a definitive test that says that a disparity actually means differential treatment, or a disparity reflects a disparate impact of an unjustifiable law. That to some degree, there's going to be an interplay between statistical evidence and expert knowledge of people who are on the front lines actually kind of wrestling with cases, and then ultimately a judgment call. But it's you know, even in academic.
I appreciate all that, but I guess my understanding, my intuition is that the differentiation in sort of aggravating circumstances in particular cases becomes less and less relevant when the number of cases you're using becomes larger and larger.
Well, so I think that when you have lots and lots of cases, then certainly it's the case that you can say, you know, this disparity between group one and group two is statistically significant in the sense that it's not likely to occur by chance. But then to then, you know, make the inference that this somehow reflects something unjust is more difficult, because then you have to control for.
No, stop before we get there, but
Yeah.
how do we say that is there a formula on just the statistically significant?
Yeah, so certainly it's, but I think that in some ways this concept of a statistically significant disparity, and whether or not disparity can be explained by mitigating factors, they're kind of independent of one another, right? That the first is a question of measurement precision, and then the second is a question of, are there factors that are relevant that should be incorporated, right, in order to make a judgment call as to whether or not a difference is observable. Like, just to take it out of a context that's a little more contentious. So we know that, you know, 80% of the prison population is male, right? Or that, you know, men are more likely to be arrested for DUIs, what have you. And, you know, if we think about that, we can have all the data in the world and we can measure that disparity very precisely to say, yes, it's men, the odds is this much higher than women. But then if you're trying to explain that difference, then you need to bring into account all the factors. So what's the difference in the rate at which people are driving drunk? What's the differences in their blood alcohol level when they're caught, and so on and so forth. And so there, you know, more data is always better, because then you have less measurement imprecision. But that's one factor, and the other factor is, can you observe all the factors that are relevant in judging the outcomes of cases?
All right. I wish no simple answer is the answer.
Yeah.
Unfortunately, which I think sort of leads well perhaps to our conversation about the RJA, because it is so complicated. There is math involved, and like I said, and then as Steve just said, it's not only math, and where the two may meet is, I guess, what we're trying to figure out. So,
Yeah.
Steve, as always, thank you so much. Let me just plug once again. We have a big report. We meaning Steve and Tom and staff and Joy and Rick and Steve's staff on the impact of 5 big resentencing or second look reforms that California has passed, including recidivism rates, think breakdown by race and county and other, I think, salient details that I think will be of wide interest. And we hope to have that report out in the next month or so without putting too much of a pressure deadline on you guys. Is that a fair
Yep.
guesstimate as well? We're going to have that out.
We're always under pressure, so it's okay. Yeah.
I'm just eagerly awaiting. I go to the mail. I go to my mailbox at the end of the driveway every day, waiting for it to be delivered. Just kidding. All right. Thank you all.
Thank you very much.
Thank you, Steve. And now I want to turn things over to Joy and Tom. So let's switch gears a bit and turn explicitly to the Racial Justice Act and begin with a brief presentation to sort of set the stage and sort of outline some of the basics of the law, so we have a common framework of understanding. So Tom and Joy, you want to take it away?
Great. Yes. Joy and I are going to be splitting this up. So let's start talking about the RJA. Joy, I'll handle the slide since there's just 2. Just tell me when you want the next one.
Sounds great. Sure. So as Mike noted, Tom and I just kind of want to set the stage and give you a little bit of a preview of some of the unresolved legal issues and some of the terms that'll probably come up in the discussion today. So as we know, the RJA was signed in 2020 and it applied to people that were sentenced after January 1st, 2021. And sort of almost every legislative session since then, we've had a bill. There's been some amendments. Some have been introduced and not signed, and some obviously have made their way into law. And the first big one was the RJA for All, which was signed in 2022, which made the RJA retroactive to any felony conviction. And this has been introduced in stages, beginning with people sentenced to death. And the sort of last group that will become eligible is next year in 2026. And that is for people who have been sentenced to any felony conviction. And in 2023, we had AB 1118, which made further technical changes. And sort of the big one was allowing RJA claims to be raised on direct appeal in the first instance. And we also have AB 1071 that has been introduced this year and is making its way through the legislature, that will make further revisions, particularly around some of the procedures and clarifying some of the unresolved legal issues, and around remedies, or sort of what options, sort of what may or should a judge do if they were to find a violation. So moving to the RJA, it allowed sort of 4 different types of claims to be alleged. And so we just wanted to put these subdivisions out here for everybody to keep in mind. A lot of practitioners refer to them by their subdivision. So the first 2 are the A1 and A2 claims that are bias or use of discriminatory language. So these are usually kind of the records-based claims or claims based on language used. And the second 2 are the statistics-based claims that are based on disparities in charging, conviction, or sentencing. Okay, next slide, Tom. And so the way sort of everything is played out, this is sort of the current process. There's been a lot of litigation around each of these things, but sort of just in general, how a petitioner gets into court is kind of follows this process. So the first is sort of a petitioner can ask the court for counsel to be appointed. And this standard is facts that the petitioner would need to allege facts that would establish a violation. Then sort of with or without counsel, a petitioner would need to sort of make the first claim in court. And then the court is going to decide whether or not they made a prima facie showing. And so this term will come up a lot, I imagine, in the discussion today. And the standard for that is whether the petitioner alleges facts that, if true, establish a substantial likelihood that a violation occurred. So this is less than the habeas standard. It's less than something more likely than not. And the RJA also provides the petitioner an ability to ask for disclosure, sort of to ask for any evidence that might be in the possession of the state. And really sort of a big open question right now that Tom will touch on is whether or not this is something that can be filed as kind of a standalone motion or sort of before there's even been a prima facie finding by the court. And then sort of lastly, sort of once the court has found that there's been a prima facie showing, sort of once disclosure is completed, once briefing's completed, the court should hold an evidentiary hearing, and the burden is on the defendant or the petitioner to show by a preponderance of evidence that a violation has occurred.
All right, so let's move on to some issues that are still unresolved or courts have resolved in perhaps questionable ways so far. So there's 8 here. There's about 3 or 4 categories. I'll go through them pretty quickly. I think a lot of these will come up in the discussion we're about to have. So the first 2 have to do with the role of statistics early on in the case. So the first question is, when you're making your prima facie case, which is sort of the preliminary one of the gatekeeping stages in an RJA claim, can you show only statistics, or do you also have to show narratives, individual cases from other people who were treated less harshly and are a different race than you? So can you go in just with statistical analysis, or do you also have to have sort of police reports or other documents talking about specific other cases? Left open by the courts, the appellate courts that have looked at it, but it seems from what we've heard, the trial courts are saying you need both, even though that presents a lot of issues I think we'll get into in a little bit. And related to that is number 2, which is, okay, if you are going to ask statistics, what exactly needs to be in there? What are the comparison groups? How far they need to go? How many factors need to be in them? Some of the stuff that Steve and Mike were just talking about. So there are, I think, big, huge questions exactly about what courts are going to accept for data and statistics in these claims. Not surprising, but it's a little bit surprising that they're still unresolved, almost 5 years in. The second group of open issues have to do with disclosure, discovery. The first one is the one that Joy mentioned about when you can file one of these motions. Can you sort of file it? And this is mostly going to be for people who are already convicted, who are coming back on retroactive claims. Can you file it before you file a motion? In other words, can you ask for information to support your motion and then file it? Or do you have to sort of get over that prima facie stage and then be able to file a motion and ask for discovery? There's a very clear split on this in the appellate courts, and the California Supreme Court is currently considering it. This is also one of those issues that the pending bill, AB 1071, would address. The second discovery issue is number 4 here, which is, okay, let's put all that aside. Let's assume you've shown the legal minimum to get disclosure, which is this good cause showing. Now, exactly what are you going to get? So courts have said, well, we have to now apply a further 6-factor test, which actually has 8 factors because one of the factors has 2 subparts, but whatever, that we are then going to apply to see what exactly you're going to get. There's really been no appellate case law on exactly how far disclosure can go, what's appropriate, what isn't needed, all that. So I think that's going to be sort of the next wave of hopefully guidance from appellate courts on this, unless the laws change. Also related to disclosure is what exactly is permissible to ask for in disclosure, from the sense of, if you want police reports, is a disclosure motion directed to a prosecutor? Can it require a prosecutor to get police reports? How far back can those go? Sort of the exact scope of what the disclosure is, which is obviously related to the Alhambra factors, as they're called, but it's kind of a distinct issue. All right, that takes us to remedies. So what happens if you win your claim, which, as we pointed out, only one person has done on a statistics case, but more people have done in these claims involving biased language in the courtroom. The courts have said there's no mandatory remedy required. So even if an RGA violation is found, there's no requirement that a court actually has to do anything about it, which seems a little surprising. This is something AB 1071 would address as well. And then even if a court is going to impose a remedy, there are some questions about exactly how far a court can go in imposing a remedy. For example, dismissing a case is not listed as a remedy in the RGA, and a court has said, well, we can't dismiss a case. You have to pick from this list that's in the RGA, which presents some issues, particularly for misdemeanor cases, because most of the remedies are, if you're doing a trial and there's a problem, you can get a new jury. Or if you have enhancements on your case, you can have the enhancements dismissed, or you can have the charge dismissed to or reduced to a lesser included. But if we're in a misdemeanor case, a lot of those things are just really not going to apply. And if the court can only pick from what's provided in the RJA, maybe that there's no ability to remedy an RJA violation in a misdemeanor case, which, as we know, are the vast majority of all criminal cases. And the last issue has to do with appellate proceedings. And one of the revisions that Joy talked about, AB 1118, I think, added some provisions about how courts on appeal should deal with RJA claims that are brought up for the first time. They say you can bring an RJA claim on appeal, but courts have said, yeah, but you have to have preserved it below, meaning you raised objections and developed everything below, which seems to be the opposite of what the legislature was trying for there. So that's a quick overview. That's already making my head spin, and I've been thinking about it for a few months. And this is just sort of a tip of the iceberg. I'd say this is a lot of the iceberg, but it's still not the whole thing. Then I also wanted to quickly just highlight the staff proposals that were in the memo. There are 6 here. The first one is easy. It's to reiterate what the committee said in 2023, which is that there should be very specific public data sources from the California Department of Justice, CDCR, that allow people to have a place to go when they need to get data while they start investigating a claim. And I think this would help defense attorneys and defendants, but also prosecutors too, because they have a place to go that is sort of a neutral place for data. And there are some other provisions there. This actually was introduced as a bill, but it didn't succeed in the year that we did it a few years ago. The second is to respond to some of the disclosure issues I just talked about, in particular clarify that disclosure does extend beyond prosecutors' offices to police departments, sheriff's departments, and similar things. The third is to expand remedies, basically give a court the ability to fashion whatever remedy it thinks is appropriate, and not limit it necessarily to what is specifically listed in the RJA. This would sort of mirror what courts can do in a normal habeas corpus petition, where they, the case law says courts have extremely broad power to fashion a remedy. So bring that into the RJA. The fourth, and we'll probably talk about this more if folks are interested, but the formalized large-scale relief. So the idea is, and Mike sort of brought this up a little bit earlier, if you are seeing a pattern of people receiving longer sentences because of their race, defendant A wins that claim, defendant B, who's in the same situation, are they going to have to litigate the claim all over again? It doesn't seem like the most efficient use of resources. So sort of have in the RJA a way to give everyone relief who would benefit if they're similarly situated, sort of like a class action type process. And the fifth recommendation, we're almost done, is to strengthen appellate review of A1 and A2 claims. So these are the ones that can be brought on appeal for the first time because they're based on what happened in the courtroom. They're based entirely on the record, and allow appellate courts to actually consider those without, going through the very rigid preservation and forfeiture requirements that they've currently set apply. And the last one is not really a law change. It's to work with Steve and his colleagues and other people to develop a sort of model process for how courts should think about determining statistics-based claims, to sort of answer basic questions about statistical analysis and ideally walk through with some data how they should think about some of these claims in the RJA. And the last thing I'll say is, depending upon what happens with this pending bill, AB 1071, if that doesn't succeed or things are stripped out of that as it continues to go through the process, a lot of things in there, I think, are recommendations worth making as well. But since that's pending, we didn't want to focus too much on those right now. Okay, that's our presentation. We can turn to the panelists now. So Mike, I'll start bringing them on board. Well, I don't know if there's any questions about any of that first, but we could start bringing the panelists on.
Yeah, a couple things. First of all, I want to take this opportunity to plug our dashboard, which is also coming soon, which will hopefully spread a lot more data on this. Tom, I don't know if this is possible to your last point about working with Steve, but in an ideal world, I could imagine, if possible, some sort of web-based interface that you could plug in certain numbers and it could maybe help do the analysis for one, if that's even possible. Perhaps that's just daydreaming. And the third is I would like to take a 5-minute break before we start panel, coffee break, bathroom break, and get started at 10:40 unless there's any objection to that.
I know one of our panelists is hoping to leave as close to 11 as possible. I know he can stay a little bit longer, but I think we're okay with a few more minutes. But I just wanted to flag that for you, Mike.
Is that Judge? Who is that? Judge Cousins?
That's Simon O'Connell. He just texted me, take the break. So I think he's accommodated us. So never mind.
Okay.
Thanks, Simon. Appreciate it.
Thank you, Mr. And we can have you go first if it's helpful. Any event, 5-minute coffee break, and we'll see you at 10:40.